You're welcome back. This is Newsfile. It's your most authoritative news analysis platform, and here on Newsfile, we put Ghana first. My guest joining us via Zoom is Bobby Banson. He's lawyer and author of legal texts. In the studio, Sylvester Tete, MP Botiano, English Yamanfro, and Vice Chairman, Communications Committee of Parliament, Kweku George Ricketts Hagan is MP Cape Coast South and former Deputy Minister of Finance. Gentlemen, good morning. Thanks for making the time to join us.
Good morning. Morning.
Great. Now, so let's bring into a certain perspective. As you know, Ato Essien, there was a judgment of the court that was supposed to have been delivered on the 13th of December, was it? 2022. And then suddenly, he and his lawyers arrested the judgment. They went with an agreement with the Attorney General to plead guilty and to pay for what he had admitted to stealing. So the amount of money standing in Ato Essien's name, which he said to have stolen, according to the charge sheet, was 192.5 million. 192.5 million Ghana cedis. But by the time they sought to settle, and he pleaded guilty to all 16 counts against him, the Attorney General had recovered 101.2 million of the amount. 101.2 million of the amount. It was detected that 35 million of the amount was seen to have been repeated twice on the charge sheet. And so 35 million was knocked off. Essentially, at the close of the day, the actual amount of money that Ato Essien was charged as having stolen was 57.5 million Ghana cedis. 57.5 million Ghana cedis. So the agreement for him to pay 90 million Ghana cedis in settlement after pleading guilty was a plus for the state. It was a good job that the Attorney General had done because they got an extra amount for him to pay. Now, the money, how did they recover the 101.2 million? They recovered it through a number of processes. They are taking a certain amount of the liquidity fund to try and set up sovereign bank. Some of that money was there and the state had access to it. When initially he was interrogated by Iyoko, they took money, seized money from him. That was also kept by the Attorney General. So let's give that perspective before we continue. Now, what did the court say on the 12th day of October? The High Court, presided over by Justice Eric Che Bafo, Justice of the Court of Appeal, sitting as additional High Court judge. Among others, the court said it did not intend to accept this kind of agreement from the very onset. It did not agree with the Attorney General. But upon certain persuasions, it had to take what they had presented before the courts. So it said it made an unusual indulgence for Ato Essien to pay the 90 million after he paid the first 30 million. And subsequently, 20 million was due and another 20 million was due. 20 million was due in April and another 20 million was due in August. He was supposed to have finished paying in December of 2023. But by the arrangement, if you breach the second installment, or call it the first installment payment, then the law kicks in and you must go to jail. So this is what happened. Now, let's go over the punishment that was given to him as in the sentence. And we are showing you on our screens all 16 counts which he pleaded guilty to. Remember, there were 4 of them. Kate Corte Papafio, the fourth defendant, the fourth accused, was discharged because her lawyers, including Eduji Tamaklo, made a submission of no case against her. And the court said she had conducted herself foolishly. But foolishly is not a criminal offense. So she was let go and was left with 3, including First Gerald Odonko and Mr. Tete. They were acquitted and discharged in December 2022. And that was the day, 13th, that Ato Essien pleaded guilty instead of waiting for the judgment to be rendered. So, let's begin with count 1. The courts gave, this is count 1, conspiracy to steal, 10 years with hard labor. Count 3, stealing, 15 years. Count 4, money laundering, 4 years. Count 5, conspiracy to steal, 10 years with hard labor. Count 7, stealing, 10 years with hard labor. Count 8, money laundering, 2 years with hard labor. Count 10, stealing, 11 years with hard labor. Count 11, money laundering, 2 years with hard labor. Count 13, stealing, 4 years with hard labor. Count 14, money laundering, 1 year with hard labor. Count 16, stealing, 6 years with hard labor. Count 17, now you find it 17 because there's a count, is it 2 or something you didn't see? Money laundering, 2 years with hard labor. So the total years comes to count 19, stealing, 8 years with hard labor. 20, money laundering, 2 years with hard labor. 22, stealing, 7 years with hard labor. 23, money laundering, 2 years with hard labor. That brings you to a total of 16 counts. A total of 16 counts. And we have rendered them the way the court gave one by one how it went about punishing. So put all together, you are counting about a total of 90 plus years, like 95 years. But because he's going to run the sentence concurrently, it comes to 15. Yes, so let's get on with this now. Beginning with Sylvester Tete.
Interesting and a good job. Thank you very much. And good morning to our viewers, my senior colleague here, and Samson, your good self, and your team. This is quite unfortunate and most bizarre way for a young man to go down in this country. And I think that the bottom line is being convicted on his own plea.
That's right.
Bottom line. So I've heard people, when this banking sector cleanup came, the interest in the banking sector cleanup. And yesterday, 3 days ago, I've heard same people or more feeling very sympathetic to the young man, asking why is he not given time to pay. He's started paying, and that is enough sign for him to be allowed time to pay. Well, without the law, on moral grounds, anybody, or religious grounds, people are free to make such comment. But we must understand that he's been convicted on his own plea, and that's what. But my take on this matter, Samson, is quite simple. There are many more banks that went down, just like Capital Bank went down.
A total of 9 of them.
A total of 9 of them. The Ghanaian people are interested in all these 9 banks and how they've been handled by the Attorney General's Department or by the state apparatus that has investigated all these banks. And I'm happy that you've laid the facts bare, and that the actual money that was stolen, and indeed has been confirmed stolen by the gentleman, was 7.5 million. But the state has added on to come to 90 million cedis, as it were. Many people thought that he has stolen more than the 90 million, and it's been part of the media conversation since this whole matter came up. And I think that the clarity has been brought on this network, and I think that people will appreciate it from this morning's conversation. That
I deliberately started on that note because I have seen across the board in the media landscape where there's no understanding. And the figures, as I outlined, were the figures as put out by the Attorney General in the courtroom.
Yes.
To convince the judge, because the judge was not amenable to the arrest.
Yes, that part of the conversation. I know it happened recently in the U.S., where the son of the president, there's a settlement of this nature, and the judge declined the settlement. That, look, I won't accept this. So the case is being tried. And I think that in this particular matter, the judge initially did not want to accept this plea that he should be allowed time to pay. Obviously, because of the sensitive nature of this matter. And like any other Ghanaian, we were expectant of the outcome of these investigations, because a lot has been lost to this country with respect to the banking sector cleanup, where over 29 billion cedis had been spent on the banking sector cleanup. Obviously, the pros and cons of it, we all know that we had the ailing banking sector, but for the intervention, obviously, we're going to crash. That would have been a catastrophic situation for this country. However, I think that the AG has done a very good job, and the investigators have done a very good job, having come to the numbers we are seeing today. You can see conspiracy to steal, obviously, and then you are charged for conspiracy to steal. That is a count. Stealing is a count. And money laundering. Look, money laundering is one thing we haven't really explained to the good people of this country well. But you're a lawyer, and then, like we say, aiding and abetting. I'm not sure one person can conspire to steal this huge amount of money. So people were hoping to see other people involved in this. And apart from the monies that were in the reserve to open the sovereign bank, and then the monies that were with him that were confiscated, to come to 102.2 million. What about assets? Couldn't the bank have taken the state have taken possession of his assets and then dispose them off to defray part of the debt? Because now he's going to prison.
It's a civil suit.
It's a civil suit.
It's a civil suit.
That would be another.
That's being pursued by the receiver.
Right. So, Samson today is going to prison for 15 years. How are we going to recover the rest of the money? It is not in anybody's interest to put him in prison, continue to feed him. If the civil suit can bring about the rest of the money, that is good news for this country. What the ordinary person on the street is interested in, recover the money and punish. As of punishment, nobody is against the punishment. He's a gentleman, nice guy, I feel for him, but he's been convicted on his own plea. And I'm interested in the rest of the 8 cases, how it's going to end.
Right.
Then there's issue of the board, the governing board of the banks. I'll have to go back and read more of the investigations into this matter. It brings to question the corporate governance structure or the culture of corporate governance in this country.
And particularly on social media. And beyond social media, they talk about the fact that for for this particular bank, Capital Bank, Dr. Mensa Otabel should also have been part of the
I'm not only looking at him alone, but the culture of corporate governance, the level of culpability in this country. I'm not too sure that 100 million cedis could be taken from the vote of a bank without the scrutiny of a board. I'm a board chairman today. It frightens me that there's no way the culture of corporate governance, if it's being pursued well, that I sit as a board chairman and whooping amount of 100 million and more could be disbursed from the bank without approval. And how was it reported? Who gave the approval? I'm not sure the gentleman went into the vote and picked 100 million and more.
The court found that there was about 2 or 3 companies, accounts that were opened, including one, Maripoma and so on. And the court found that they were deliberately opened so that the monies would be transferred into those accounts to be used to set up the sovereign bank.
No, so it's a board decision.
So you had 60 something million being pushed into each account.
However, look, even to assess a 1 million CD loan from the bank, it goes to the board. There's a threshold for the MD. And it's a standard practice. When I was a CEO, in procurement, I have a threshold of 100,000. Beyond that, you go through tender. At the board meeting, there are things that the MD cannot do. It has to go through the board for approval. These are things that should be investigated. And I don't want to say because it's Mensa Otabel. We are looking at the corporate governance structure. It has been brought to question. And we should even extend the conversation to that extent. Otherwise, how could an MD, how was the bank even open, for what purpose? Who gave the approval for the bank to be opened, the sovereign bank, intended sovereign bank, to be opened? Who are the directors of that bank? If the money gets into it, intended bank to be opened. So who are the supervisors of that account? Is he a sole signatory to that account? How could he have accessed monies from an account that is intended to open a sovereign bank? I mean, these are legitimate questions that we need to ask. It is not enough that the monies has been recovered, but there are more work to be done. There's so much work to be done on this particular investigation. Yes, I'm happy that the monies have been, about 32 million more has been recovered from him. 37 million cedis more. So he's left with about roughly 53 million to be paid. So somebody asked, assuming the family is able to put up this money and go to the bank, what will be his fate? Is he going to be released from prison, or he will continue to serve on his own plea? So I think that, for me, there are more questions to be answered.
The Deputy Attorney General has been saying,
yes,
and I share that view though, that once the court has given its judgment,
that's fine,
convicted and passed the sentence. In fact, he was convicted in December. Let's not forget that. He was convicted. It was sentence that was suspended pending payment of the 90 million. Failure to do which he was to be sentenced accordingly. The Deputy Attorney General has been saying that once the court is finished with its job, it's done. But if he is able, within this, any time from now, to pay the remainder of the money, then he can go on appeal.
Okay.
He can file an appeal and ask for the sentence to be reduced.
Interesting.
Yeah, but he's happy that they've gotten this. And in the history of this country, criminal prosecution, this appears to be
a huge
like
success.
the first. You don't have anything like this done before.
So I think it's also part of the reason why many people are not cautious when it comes to criminal prosecutions. Because all the criminal prosecutions we've had in this country, it ends up nothing. Sometimes you get some few years in jail and that's it. But the booty itself had never been attached as it is. And I think that has been a huge success. That's why we celebrate this case from the AG's point of view. However, some of us are interested in the culture of corporate governance, how it assisted in this conspiracy and all that. Because when you talk of conspiracy, one man cannot conspire with himself. There could be multiple factors that comes together to make it complete. And that's where I'm particularly interested. And we are following keenly with the rest of the banks that have been closed down. Until that, the public confidence has to be heightened by way of how we do our things. And investigations, I believe that is public. It should be made public for everybody, the details of it. I mean, the fact that you recover the money does not mean that everything is sacrosanct. We still have to ask more legitimate questions. But until then, for what they have done, the success in this case is it's a yeoman's job.
The AG said they really wish that they had gotten all the money because that was their interest.
Yes, certainly.
And that they've gotten 37, the rest could be lost.
They are close to recover the exact amount.
Yes, the rest could be lost to them.
Yeah.
But something came up in the court. The court said after the length of time allowed to Essien to make the payment, the court said, as a matter of fact, a very material allegation made by Essien against the imposition of custodial sentence was a claim that an agreement had been reached between Essien Swiss Limited and a company known as Panarico Limited, for which Essien Swiss was entitled to periodic payments for the sale of its assets or which same was to be relied upon to make payment to the state. Unfortunately, this entity, where he was getting money to help make the payment,
You have to investigate
had also been sued.
by the
And
receiver.
some people were levying judgments on that entity. So the court said, from the way it looks, he has lost opportunity of that money that was going to be coming in. So he's not going to get that money. So even the lawyers were asking for 6 more months. And say, if we give you the 6 more months, the source of money that you are going to get to pay is no more there.
I mean, it has to be reasonable.
So what are you going to do? Then there was this other part that the court said he indeed made an offer of giving his water treatment plant located at Pram Pram, which is valued at $10 million US.
How?
Enough to offset the outstanding amount of 53 million Ghana cedis together with the judgment debt that has been procured by one other company.
Something.
Now, this were his lawyers telling the court.
Who valued
Some
it?
people are saying that if this opportunity was there, that he has a property that, even if it's not $10 million, supposing it's something close to, it's $5 million. If you give him time, maybe he could pay. Why didn't they wait rather than get him in jail and lose the opportunity?
Something. The court will look at the reasonable grounds or possibility. I know that property very well in Pram Pram. Obviously, yes, it worth not more than $2 million.
Oh, really?
Of course. I mean,
You can't say that.
I
This
can't.
must be a proper valuation done.
I wonder who did the valuation.
But you can't use your eyes to just...
Seriously speaking, it's a water treatment plant. I don't know what kind of equipment in there. The size of the warehouse and the office in front of it. Obviously, cannot worth $10 million. That notwithstanding, for me, I'm also interested to know, the agency will help us to know how much it costs to do this prosecution. It will really help Ghanaians so that we weigh the cost of doing this prosecution as against what the state is getting. We should be interested in this, and in other jurisdictions, they put out the cost, the detailed cost of prosecution in these matters.
I'm sure they factored that in. That's why they got an extra.
Yeah, but
rather than
they should
the
be able to tell us. So now that we are not getting the entire money, as it were, obviously the state is losing a lot of money. So preventive aspect of
The
this.
state will not have spent $5 million doing this.
Well, you can't tell that. Well, you're a lawyer though, but
You
of
can't
course,
spend.
the
You will spend $5 million.
You too, you are not.
But they
haven't been able
got
to
so
evaluate
much
it.
in extra. excess.
You may not. You can't say that for a fact. So the state, we are interested. The state should be able to tell us, and periodically they should be able to tell the good people of this country how much it costs to be able to do all these things, so that we strike the balance. But I think that, unfortunate as it is, I think that the right thing has been done. It's a big lesson to all of us. And like I said earlier on, members who serve on various boards of financial institutions or otherwise, the temptations are quite high, but we should be guided by the principles and the legal remit within which we work. Other than that, we'll find ourselves. I mean, if all other 8 cases are being prosecuted and we get to the final conclusion, obviously some people will be able to have the financial muscles to pay. So they should surge on and make sure we recover all monies to the state.
All right.
That's the
Thank
huge
you.
lesson. I remember when
Yes.
this matter came, people were like, oh, he's been persecuted, he's a young man, he's opening opportunities
People said that.
Yes, of course. I mean, in the media space, that this is a young man who is creating job opportunities for young people and all that. They've said all that. But today, the bottom line, the gentleman has been convicted on his own plea.
That's right.
Settles the matter.
Right. Now, Kweku, what do you say? He had waited until they had done prosecution for a very long time. The state had called 17 witnesses. And they said, the judge said, why did you have to waste our time this way? So, whilst the judge was minded to exact a hefty penalty, he still felt and he noted that because of the payments he has made, he would also consider that. So the judge said, for example, stealing alone is 25 years. 25 years. But see how he came. He came to 15. Good news?
Samson, good morning to you. It's been a long time. And good morning to my brother, Sly, and your cherished viewers and listeners. This is a very interesting case, and it's actually much, much bigger and goes beyond Ato Essien. As Sly said, he admitted to the crime, and therefore he must do the time. He had the opportunity to pay, and though he made a substantial amount of initial payment, that's about a third of what he was supposed to pay. Probably he ran out of money. There could also be other
It became
reasons.
obvious he ran out of money.
Yeah.
When he paid the 30 and he was supposed to pay 20 later,
He did
you
five.
found he did, yes,
Five and
5. Yeah.
So obviously,
He was doing piecemeal.
diminishing return. So it was still quite a substantial amount of money for him to come up with. So that itself, without any hard evidence, tells you that he did the crime. Obviously, where did he get a 30 million from? I know he was the CEO and it was his own bank. But you see, it goes beyond that. I mean, Sly talked about obviously corporate governance and other things. But it even goes beyond that. Because, Samson, human nature, if philosophers will tell you, human nature itself is self-centered, self-interested, selfish. Even people with good intentions or doing something good for society could somewhere along the line, where the self-interest and other things kick in, will try and maximize things for themselves. It is for that reason that we have the police, for instance, or we have people who are supposed to provide, basically responsible for regulatory responsibilities, supervisory, fiduciary, and all the things that, the central bank, that's the Bank of Ghana, does. It is clear that it's not only the board that failed in its judiciary responsibility in terms of governance. Fiduciary responsibility in terms of governance, but the central bank itself also failed in its supervisory and regulatory responsibilities. And that this bank and many others were able to get away with things because of the weakness of the regulatory system. And it surprises me because when you go through all the banks, there were different issues. Others even presented, if that is true, fictitious document to set up some of these banks. That is a clear failure of the regulator on not being able to find these things out. It is surprising. We are talking about board members not being called to answer questions. It's also surprising that officials of the Bank of Ghana nobody has been called at the Bank of Ghana to answer any questions.
I think they gave an indication earlier that the investigation will not end with these private entities, but also people within the Bank of Ghana in the regulatory system.
Well, I don't think we have gone far enough, quick enough. And that the longer it takes, I mean, I know you lawyers say, the wheels of justice grind slowly and all that. But it clearly tells you that there is a failure in our system, especially the banking and the financial system, that what we have done and called a financial cleanup or bailout itself was not, the government did not think through it very well. I know Sly will disagree, and he's already, that they did that to save depositors. They talk about 4 million or so and all that. But if the root cause of the problem has not been resolved, spending 25 billion or 29 billion is not going to solve the problem.
It's only 29 billion.
25 that I know, okay. 25 billion. I think Sly mentioned 29. Maybe he knows more, something more.
We have heard sometimes you hear 20.
I mean, the number keeps changing. So I mean, when you even look through the budget, every year comes up. But I guess they are still, spending.
We understand money. That this 25 billion is part of why our economy, the shocks were not strong enough.
Absolutely.
And therefore we are suffering all
Absolutely. It's very clear that spending and that's where we disagree. That, again, let me use this simile, as the literature people call it, that what this government did was to throw away the baby with the bathwater. What our option before we left office was to throw away the bathwater and save the baby.
The claim was that about 8 billion of that amount could be used to survey the situation.
Even less.
Okay.
Because even when the MPP came to power, they increased the minimum capital, they took it from 120 to 400. So even at 400, if you want to save all 9 banks by recapitalizing them with the full minimum capital requirement, you will only need 3.6 billion to do that. That's 9 times 4. So having to use 25 billion to do what I believe, yes, you talk about.
But when you talk about 9 banks, you don't forget that there were also 347
Absolutely. When you add it all together, about over 420, but I'm talking about just the banks. And then you probably will require the same amount of money. So maybe, yes, if you say 3.6, maybe 4, so maybe another 4 or 5. So 9 would have done the trick. But to go and spend 25 billion, and it doesn't look as if the problem has actually been cured. There is still a systemic risk in our banking. There is lack of investment coming into the banking sector. Banks are not doing well, but we are given the picture that these banks are doing well. The banks are not growing because what they have basically done is a forced acquisition of banks that were weak, added to other banks that were already weak.
To GCB and to consolidated.
Absolutely. So you will look as if your customer base actually grown, but it's not an organic growth. It is basically adding on to it.
But what do you think about this judgment that it's deterrent? Those who are also in similar circumstance, those who have already been put in court, those who are about to be put in court, what do you think may be going through their mind as they...
It's definitely the case that people should not be allowed to do things against the state or against all of us and get away with it. As you said, this is probably, in my recent memory, the crime case that seems to have seen some light in the day. And there's so many of this, and we never get any finality to it. So this is good. This is a deterrent. Those who are yet to be, to be looked at, I hope that they are able to find the evidence to also prosecute them if they have done something wrong.
Okay.
But this prosecution and all the things that are going on could have still been achieved without necessarily closing the banks.
That's what I'm
saying. The bathwater, you can throw it away and save the baby.
Right. Let's go to the lawyer, Bobby Benson.
The bathwater in this case is the likes of Essien.
They did it. And the monies that had been stolen were part of the monies that you gave for the purpose of which you are suggesting today. And you failed to control. And these are the results. So what were you talking about?
This was done in 2016.
The banks were on their list 2014. You gave them money. You gave them money.
But there was a report.
A report. You gave them money.
Yes. There was a report that was commissioned. That was done.
Yes.
That showed that the banks were not in good health.
No. When we did the asset quality review.
That's right.
It highlighted the distress or the challenges that the banks had at the time. And some of the remedy was to give them this liquidity support while we tighten the laws in terms of regulatory
When you gave them the
we have
liquidity
the
support,
system,
how did you supervise that?
and also protect customers.
All right.
It was a process.
Bobby Banson.
And they had a knee-jerk reaction of basically just closing the
Let's get the lawyer to try and explain something.
Away with the water.
Something for our viewers and listeners on. Hello, Bobby.
Hello, Samson.
Great, good to have you, Bobby Banson. Now,
and greetings to my senior colleagues in the studio.
Right. The judge said in one of the sentences, he said, I was minded to impose a sentence close to the maximum of 25 years. However, taking into consideration that an amount of 37 million Ghana cedis has so far been paid or recovered, I impose a sentence of 15 years. That's in respect of stealing. Now, we have seen 16 counts, pleading guilty to all of them, and therefore being sentenced on each one of them. In totality, in excess of 90 years. How come he's going to do only 15 years? Which, in fact, if you look at the prison, how the prison service works, it's not exactly 15 years, it's less than 15 years.
Well, I believe that once the judge had found him, or he had pleaded guilty to each count, the judge had the responsibility or the jurisdiction to pronounce the sentence on each count. And so for each count that he had pleaded guilty to, there must be sentencing after the conviction on each count. However, the judge has the discretion based on the circumstances of the case to decide whether these sentencing will run consecutively or concurrently. And by concurrently, it means that whilst he's serving time for the conviction on the stealing, he would also be serving time on the conviction for the money laundering. So every day that he's in prison for all the offenses that he had been convicted and sentenced for. So it means that it is the one that has the highest number of years that he will end up spending time for. So if the stealing, then we know that the judge could give up to 25 years. The judge decided to give him 15 years, with the others 2 years, 3 years, as it were. It means that at the end of the period, it is the maximum sentence period, custodial period, that he would be made to spend time for.
Okay.
And the 15 years for these circumstances, it's unfortunate that somebody who had been celebrated as a young Ghanaian at that time started, we all know before it became a bank, it was a microfinance, developed, obtained license, and all of that. That would be the end of his business empire. But that is what it is. We are where we are, and it's a lesson for all of us, and a testament to the fact that justice is no respecter of persons.
Right. Now, people also want to understand, on the back of what the Deputy Attorney General said to the media, that they wish that they had gotten all the money, but, well, they are happy they have gotten 37 million, and that they didn't lose that one, and the potential that even what is left could also be lost. People are asking, then why was the Attorney General in a hurry to go back to the court to ask for the custodial sentence when, according to the agreement that they reached, the agreement expires in December of this year? Why didn't they wait? So, and I'll show something here with you. The lawyers for the accused, for example, said, quote, "We are not taking advantage of the leniency that the court has shown us." Then they prayed that the court should temper justice and give us more time. They asked for 6 more months. Then the court said, "I have heard learned counsel praying for further time for the convict to pay the outstanding 53 million. The basis of the prayer is that there is an appeal pending in respect of a certain case, and also the, they relied on a certain Asian Swiss, which they said was going to be giving money to them. And that had become a matter for a court when there had been a judgment. And the court said, therefore, that they cannot abide by the uncertain date in the future for that to happen. The lawyer also indicated when he was, and this was only when he was doing mitigation, I must state that to you, that he had property which he made an offer of giving to the state. It says, indeed, he made an offer of giving the water treatment plant located at Pram Pram, which is valued at $10 million, enough to offset the outstanding 53 million Ghana cedis, and also the debt that other people have sued them as an Essien to get. Why do you think the state could not wait for this, but put him in and potentially lose the opportunity of getting all the money?
Well, I think the Attorney General acted based on the provisions of the Section 35 that even allowed the plea bargain in the first place. That provision states that if for any reason the convicted person, because at that time you are already convicted on your own plea, you default in any of the installment payments, the Attorney General must go back to the court and then ask for the entire sum to be due and payable, in default of which then there will be custodial sentencing. And so as you narrated, Mr. Essien, after the first installment, kept defaulting in the other monthly or the scheduled payments, and kept asking for adjournment and giving reasons why there is the delay. But at that point, like we know, once you owe, you've agreed to pay, the creditor, in this instance being the state, is not concerned about how you would raise the money. They're only interested in getting the money due in the state account within the time. And since the law, the Section 35, states that once you default in a single payment, the AG would come to court and ask for all the amount to become due. If you are not able to pay all the amount to become that had become due, then the court must then impose the custodial sentence. You said this morning, Samson, that the plea bargain only means that the custodial sentence has been suspended.
In fact, indulge me, this is what the court said on that. So he was supposed to pay, the next payment was due on the 28th of April 2023. On the 28th of April 2023, there was a payment to be made on the 31st of August 2023, and then the final payment was to be made on the 15th of December 2023. So the dates again, which he defaulted. The second payment, or which is rather called the first payment, separate from the deposit of 30 million, was to be made on or before Friday, the 28th of April 2023. Then the second one was to be made on the 31st, on or before the 31st of August 2023. And then the final payment was to be made on or before the 15th of December 2023. Now, this is what the court said. The court said, the court accepted the terms of settlement and noted in the judgment delivered on the 13th of December 2023 as follows, quote, the passage of custodial sentence is hereby suspended. However, the guilty plea and the conviction would always hang around the head of William Ato Essien as a sword of Damocles until all the monies have been paid in accordance with the terms and timelines agreed and accepted by the court. I order that if the convict defaults in the first payment of the amount of 20 million Ghana cedis or makes some payment short of that 20 million cedis by the 28th of April 2023, the whole of the amount of 60 million Ghana cedis shall become due and payable by the convict upon failure to pay to the terms of the agreement entered into and adopted by the court, with its further conditions imposed by this court. The agreement will be deemed to have come to an end. In that event, the prosecution shall immediately, after the expiration of the whole of the day of 28th of April 2023, cause the immediate arrest of the convict and produce him before the court as soon as practicable for the custodial sentence to be passed on him according to law. But why? There's the 15th of December. Why don't you wait till then to see whether he has paid all of the money?
Well, like the judge, and that's Justice Chebafo, he's very meticulous in his rulings. He will cover every aspect. Whether you agree with him or not, he will let you know that he considered every aspect of the argument so that you are not left in any doubt that he understands exactly what the position of the law is. Remember, the plea bargain law actually gives the judge some discretion to even refuse to accept the payment, which he exercised that discretion when they came to him with the first offer for settlement. And so he was informing both the Attorney General and the lawyers for Ato Essien that I also have a role to play in this whole thing. And that in the event that there is any breach, do not think that I will entertain any attempt not to deliver justice as dictated by the provisions of the Plea Bargaining Act. And so with the 28th April breach, not default, not payment, the 15th August, no payment, I think the Attorney General may have assessed the entire situation. I heard you said that the lawyers had even offered that they had a 10 million worth of
water
property.
treatment plant.
Yes,
$10 million.
And Honorable Sylvester said, with his naked eyes, that property is not even worth $2 million. And so if the Attorney General had assessed the situation and they are convinced that there was no money coming from anywhere, I believe that they just decided that they don't have to waste anybody's time because the state also loses resources continuing to prosecute this case. Remember, Justice Chebafo has been promoted to the Court of Appeal.
That's
has
right.
had to come back all the time to finish this. And so I think in the previous discussions involving the Attorney General, they had stated that there was not any traceable asset of Mr. Essien that could be attached and sold in satisfaction of the judgment debt. And so if the state thinks that upon this or these two dates that there has been default, there's no light at the end of the tunnel. We don't have to waste anybody's time. Let's just go for the head of the man and put him in jail. At the end of the day, if he is able to make further payments and he has filed an appeal against the sentencing, the Court of Appeal may look at his attempts to restitute the state and then decide whether to reduce the sentencing based on his subsequent conduct.
Right. The judge had actually noted one thing too, which is worth, reading. The property that they said was seeing to the sale of their assets and out of which he was going to get periodic money periodically and then used to pay the judgment sum or the settlement sum. The court had this to say about that. He said, the property from the record subsequently made available to this court shows that the property has been the subject of execution by a company called Keymed Travel and Tour Limited. This fact was known to William Ato Essien at the time he made the deposition to use the same to pay the monies owed the Republic. And yet he did not deem it fit to have made full disclosure to the court that the property was encumbered. The judge was angry about this. It took those who got judgments in that case to write a letter to the court to bring this to the notice of the court. Do you think this also got him to not reduce the sentence as much as it was expected may have happened?
The imposition of sentence is at the discretion of the court. The court will look at all the circumstances of the case, the sign of remorse by the convicted person, the conduct of good faith. And like I said, Justice Chebafo is one that will let you know that he has considered every possible angle. And so he will bring it in the judgment for you to know that, hey, if you intended to actually liquidate this amount, you would have made it obvious that, okay, this property has been encumbered, so it cannot be a source of funding within the within the short to medium term. These are my assets. And I believe that he, as the sitting judge, should have considered all these facts before deciding to impose 15 years. He could have even imposed 20
I understand that this involved a lot of money, which was going to come to him. And the judgment against that company was for only 7 million. So he may not have erred in saying, I'm going to get money from here.
But something we all know, that when a property is encumbered, before you can discharge it from the attachment and make it available, that process, if it's litigation, can even take 2 years.
Right.
3 years. But there was a deadline for all these monies to have been paid, which is December 2023. And so the judge, sitting there with all his experience, saw that between now, October 2023, and December 2023, may not be an opportune time for that property to have been discharged of the encumbrance and subsequently liquidated, to enable Mr. Ato Essien to make...
As if you are in the mind of the judge. And this is what the judge said. That it's, after noting all of this, he says, clearly, therefore, the likelihood of any monies emanating from any sale of the Pram property to liquidate the monies that the convict agreed to pay before this court was only unlikely to materialize, even if the court were to afford the convict the further 6 months being demanded.
Well, there we go. Like I said, as to be expected of Justice Chebafo, he will let you know he has considered every possible angle. And it's like we said, we are not celebrating the imprisonment of Mr. Ato Essien. I believe that his story, his success story, was one that inspired a lot of people. But as it stands now, it is what it is. He pleaded guilty, agreed to make the payment within the time that he signed. In negotiation, he could have asked for 2 years. He could have asked for 3 years.
Right.
But he decided to ask for up to December 2023. And the law is very clear. If you default in doing so, the court's jurisdiction to pass the custodial sentence would be invoked. And so he had to lie on the bed that he's made. It's very unfortunate, but it is what it is.
All right. A final thing I would like you to help us look at is, and there's this book-long guy at the presidency, the vice president's office. He's a neddy of a vociferous, a voracious reader, Evron Hughes. He said, on the back of these things that was going on social media, I checked his account a number of times, his platform. He said, on Judgment Day, accountability is personal. So people must watch. People are saying, what happens to the other board members? What happened to Dr. Otabel? Why is it that this guy is being sacrificed and so on and so forth? That's why this statement is sort of critical for me. He says, on Judgment Day, accountability is personal. What would you say to those who are saying that it's not fair to deal with him the manner he has been dealt with?
Something. In respect of why the other members of the board are also not facing charges, right?
Yes, particularly Dr. Mensah Otabel.
Well, let me make this disclosure. I attend Dr. Mensah Otabel's church, but I have not had any personal dealings with him in my life, ever. I have never represented him in this. But this is my understanding of the law, as I see it, as I say it, irrespective of the persons involved. Now, corporate governance dictates that if you're a member of a board, either executive or non-executive, even to the point of board chairman, because before you become a board chairman, you are a director first. And so in that role, if there is any conduct of the company that is approved by the board, then the members of the board together as a unit are responsible, either in a civil proceedings or in a criminal proceeding. However, because criminal law dictates that before you find somebody guilty of a criminal offense, you must be able to prove the mens rea, the intention of the person. And so there are various angles to this. There is the criminal negligence, and there is the mere civil negligence. Now, the members of the board of the Capital Bank is not only Dr. Mensah Otabil. As you stated in your opening, in your submission, Samson, there is a lady, Madam Kate
Kote Papafio,
who was also charged with these persons. And at the end of the day, her lawyer submitted a case of submission of no case after the prosecution have closed their case, and she was discharged and acquitted.
That's right.
That is one. Two, the Attorney General has stated that they took or they questioned or investigated, for lack of a better word, every single member of the board, not only of Capital Bank, but there are other banks that the board members are also facing. Some board members are facing criminal prosecution. I can readily speak of the Unibank case, where some members of the board are facing a criminal prosecution. Something you know that in the Unibank case, some board members are acting as prosecution witness. In the Unibank criminal case, some of the directors are acting as prosecution witnesses.
In the Capital Bank case, it was no different.
Yes, so it means that the mere fact that you are a director of a bank or of a corporate entity does not mean that they can impute criminal intent on you when the company acting through specific persons engage in crime.
All right.
And so there again, you have an instance where Mr. Ato Essien has pleaded guilty alone. If Mr. Ato Essien's legal team or himself were convinced that there were members of the board that participated in the crime, nothing stopped him from mentioning these members of the board in the course of the investigations or the report.
Okay.
He would not have taken the full responsibility to pay all these monies if he wasn't the only one who spent it.
Okay.
Now, on the flip side, I am aware of civil actions that have been commenced by the receiver against companies such as Otabil and Associates to recover monies that had been paid to these companies.
Civil process commenced on the 2nd of November 2018. And anytime we discuss this issue here, the criminal aspect, I have given the disclosure that I am counsel for Ato Essien in that case.
Very well.
Yeah, so
and
go
so
on.
you see that the same set of facts could give rise to criminal prosecution and civil liability.
That's right.
If the Attorney General was convinced that there was any criminal intent, not only against Dr. Mensah Otabil, but other members of the board, because the board of Capital Bank was not only Dr. Fitzgerald Odonko, Mr. Tetenate, and Dr. Mensah Otabil and Ato Essien. There were other members.
That's correct.
And so if the Attorney General was convinced that there was criminal intent on the other members' part by this siphoning of accounts, the Attorney General would have brought the prosecution against them.
All right,
and that
thank
is why
you.
I have said that these discussions or these comments on social media, if we are saying that as a nation, we need a public inquiry because something you made reference to corporate governance. You see, before 2018, the Bank of Ghana did not have any concrete corporate governance requirement or restrictions for the financial sector.
That's correct.
For example, somebody could be a director, a managing director, or a director of a bank for 10 years. It did not happen in any country. But in Ghana, we allowed it to happen. And so I believe
now
that
you can do that only for 4 years, right?
Yes, for 4 years. So the PricewaterhouseCoopers investigative reports that has detailed the causes of these financial collapse is in the public.
Okay, thank you.
That engaged in criminal conduct is the one that...
Thank you about that. And the reference to Kate Kote Papafio, the fourth accused in that case, this is what the court had to say when the court discharged her on the submission of no case. The court said, the fourth accused person acted childishly, but the law does not punish the foolish, but the one who acted with evil intents. End quote. That's how that businesswoman got off. The others if you look for the judgment of 13th December, you should find it. And in the civil case, let me just list what you find in there. In the civil case, the first defendant, there are 16 defendants. The first defendant is William Ato Essien. The second defendant is Mensah Anamwa Otabel. Third, Oheniba Osei Akoto. Fourth, Stephen Encho. Fifth, Kingsley Atta Gansa. 6, Otabel and Associates. 7, International Central Gospel Church. 8, Kwejo Eisi Ashring. 9, Isaac Osa Thompson Mensah. 10, John Kofi Mensah. 11, Edwin Obeng Donko. 12, Fitzgerald Odonko. 13, Amadou Montia. 14, Kofi Kwakwa. 15, Francis Edumante. And 16, Isaac Osei Thompson Mensah. And if you check, there are clear amounts that are being demanded against each one of them. And they were said to be shareholder loans that were advanced to them. So if you see ICGC, for example, they are supposed to pay, they are being asked to pay 7 million plus thereabout. So that's true. There's a civil case that is also going on side by side. We'll take a quick break. When we return, we'll briefly deal with the OSP's petition for the removal of the judge. And then we'll move to Professor Frimpong Boateng's report that the Attorney General says is empty, contains no evidence to be used to prosecute anyone. Why are people angry about that? We'll be right back.
The professor had made specific allegations against named individuals in his report. The president had directed the CID to investigate the allegations. The CID of Ghana Police Service indeed built a docket after critically going through a process of interviewing and indeed examining all the persons who were named in the report. Each of the individuals named in the report, a statement was taken from them, and against whom allegations have been made by Professor Frimpong Boateng. In the statements given by each of the individuals, they categorically denied any allegation against them.
But that is expected, isn't it?
Precisely. So then what is the burden? The burden then is to investigate the matter further. And who was in a better position to assist the CID with the conduct of investigations than the person who alleges that these individuals were engaged in wrongdoing? And the professor clearly, as recorded in the docket of the CID, refused to cooperate. A number of attempts were made to take statements from him. He even refused to give a written statement. He stated that he was relying on the bare allegations contained in his report. The CID proceeded further to probe all the allegations against each of these individuals. And they could not unearth anything at all.
You're here on Newsfile. This is your most authoritative news analysis platform. And here on Newsfile, we put Ghana first. You call yourself the Yao Ming. He's just a scapegoat. They won't tackle any other person. They are just using him to score cheap points in case a challenge is thrown at them in relation to the corruption in the banking sector. Felix Tabim also says, I suspect his prosecution is because he went out there to talk and even spoke in other tongues. As long as the others negotiate with them, forget it. Rauk GH says, I think his sentence is a win for Ghana. Let's take steps to recover the outstanding amounts. There's no order in the judgment for any outstanding amount to be recovered. I stand to be corrected, but as I have read the sentencing order, I don't see it there. Maybe in the main judgment that was suspended. But you have heard the Attorney General they have not told you that it is there. So there's no such order. Nieko Kompa 1 says, in Ghana, nothing can ever happen to a sitting government member, even if it's common branch executive who goes against the law of the country, while more talking about those at the top there. Don't get the point. Perot Musa says, if this man were an MPP member, guess who would have stepped in to clear him? Annan Son John says, those who spent huge amounts of money to collapse the banks should be in jail, not those who were facing business challenges. Interesting comments there. And Kojo says that, but he was charged with conspiracy as well. Who did he conspire with? Well, there are three others who were acquitted and discharged, so maybe that's all about it. People like to read a lot into stuff. Prince Henry Koforidia says, Ato Essien is jailed. What happens to Dr. Mensah Otabel, and why is NAM1 still walking free? Family and friends, MPP government led by Nana and Baumia, we collapse indigenous banks just for some selfish reasons. Really? As we speak, President Akufo-Addo hasn't made any comments on the happenings in the Volta region regarding the dam spillage. Nana-Addo must know that he is the president for Ghana. The future is pregnant. Thanks for your message as well. But I guess we can pause here with your messages. A very final one, Musa Bato says, I find it difficult to understand why Ato Essien was sentenced alone. He pleaded guilty to the charges. Is it because Ato Essien refused to sell Capital Bank to Data Bank? That's why he's languishing in jail. If Ghana were the bona fide property of the Akufo-Addo, Kenoforiata, and Baumia, will they have used 20 billion to collapse banks instead of using 8 billion to keep them afloat? All right. Thank you for those messages. Now, let's get back and very briefly, as I said, very briefly on the special prosecutor saying that, asking the Chief Justice to have the judge recuse himself or take his cases to other places. My guest, Bobby Banson, Sylvester Mensah, Sylvester Tete is still here. Kweku Ricketts-Hagan is also still here. Let me begin on this note with Bobby Banson. Bobby, in law, is this unusual? Is it not normal? Why do you think it's taking the attention of the public this way?
Well, it's not unusual. I think in our own private cases, you had cause to believe that the judge may have made prejudicial statements in the course of the matter that made you think that the judge had already is biased.
Exactly what they think.
Sorry? Something?
Exactly what they think.
Yes, and there are various means of pursuing this angle. You could petition the Chief Justice, which I believe the OSP has done, or you could actually file a formal application for prohibition to the Supreme Court in exercise of its supervisory jurisdiction to restrain the judge from continuing the case, and for the Supreme Court to ask the Chief Justice to transfer the matter to another court. Remember, it is only the Chief Justice, per the provisions of the Courts Act, that can transfer suits to another matter. Now, what was interesting for me is the fact that the OSP has filed criminal charges against Madame Cecilia Dapaah only for refusing to provide certain information to the OSP. So it is not as if Madame Cecilia Dapaah has been charged for the money laundering, corruption, those things that the OSP says he's investigating.
And that matter is also before the same judge.
Exactly the point that, icked me, that raised my interest, that the judge exercising, for lack of a better word, jurisdiction in the investigation applications, the interlocutory applications, is the same judge that this matter has been sent to do, to handle the criminal charges. And if you read some of the contents, and this is without prejudice to the outcome of the petition or without prejudice to the investigation, I'm only saying based on the facts that are available before us. If you read the contents of the ruling of the judge in the original application that was filed by the OSP, to freeze the first one, the account.
To freeze and confiscate the monies.
That the judge dismissed. The judge made certain comments that went, I think, in my humble opinion, that went beyond the ambit of the original application. Because that original application was to freeze the account. If the judge was of the opinion, which I agree with him in terms of the law, that the application should have been brought within 7 days, and it was brought outside the 7 days. And so the application was dead
was
on
caught by
arrival,
time.
as lawyers could say. I believe that it could have ended there. But to go beyond to make comments on how the Madame Cecilia Dapa would suffer, and I think those comments have also featured in the previous appearances before the judge. I think this week or so, that he was abridging time for some applications because, in his opinion, Madame Cecilia Dapa is suffering or would suffer, as it were. Then it gives the OSP that basis to seek, those prohibitory orders in whatever form. Again, I'm not saying the OSP is right. I'm only trying to explain it from the facts that have been laid before us. Now, whether the Chief Justice will exercise the discretion to do that or not is another matter.
But Bobby, normally it is we, the private practitioners, who raise issues against judges we don't want here and there, not institutions of the state. Is that not the case? Is it not?
Yes, but I believe this goes to show how the states are working, the state entities are independent of each other, no matter what the public perception is. Because one would have thought, or it's been said, that if you are going against a government entity, as it were, the OSP being appointed by this government, him going against the government appointee, then it should have been something that would have been, gone the other way. But you see the OSP, and for me, Samson, because this is the first time we are having the OSP, I'm really happy with the way we are testing the law, the OSP Act, because there is also an application to restrain the OSP from investigating, which I find very
a human rights application.
Human rights application, which I find very interesting. Now, we want to see whether a high court or a judge, for that matter, would restrain a state entity from carrying out its statutory mandate
of investigations.
But
this is not strange. You remember Charles Bissiou has filed a similar process, right?
That was what, and you remember my conclusions on that part, that the Supreme Court has made it clear that you cannot use an injunction to restrain an entity from discharging its statutory obligation.
Okay.
Or mandate.
Let's be careful. So we are not found to be commenting on the substantive matters.
I agree.
We here at Multimedia, Cecilia Dapa has already sued us in defamation. So we have to be careful. We can't afford too many of these things. It costs a lot to defend these matters. But you said, apart from petitioning, or instead of petitioning the CJ, you could actually file a prohibition process in the Supreme Court.
Yes.
But don't you think that normally the grounds that you advance for against a judge sitting on a matter, if they put it in a suit, that would be embarrassing, because if the grounds include very sensitive matters, they would have, if they put it in the suit before the court, that would become a public document. But when you file a petition to the CJ, that will be done in camera, closely. Is that not the best way?
Well, it's as it stands now, we have the OSP, and I think that it's a very wise decision, has not made public yet. I have not seen it yet, the contents of the petition. You see, the petition to the Chief Justice would be in exercise of an administrative role as the head of the judiciary. But once you file the prohibition application to the Supreme Court, then you are asking the Supreme Court, which the Chief Justice may not sit on that panel,
right,
to exercise its supervisory jurisdiction. And that is where, because the Supreme Court said in application for prohibition, it is not mere suspicion of bias or prejudice. There must be concrete evidence. And so the basis that the OSP office has to argue that the sitting judge is biased or has made prejudicial comment, like you rightly said, must be properly outlined in the affidavit in support
right.
if they file an application on prohibition. So I believe they have looked at the public angle, sentiment, and to let it be as if maybe that they do not want to, or they are seen to be antagonizing the judge.
Well,
rather,
as you have heard me suggest before, I think it will be a lazy media house that will not follow anything that the OSP is involved in a court. So I think that maybe it may be the best way to do a petition which will be heard in camera than to put it in a suit, which the media will definitely go and get it and start serializing, you know, if it is certain matters that you don't have to put in the public. All right, thanks for that. What do you say about that too?
I mean, something, this is quite court-owned processes. I mean, this is not the first time somebody has petitioned a court for a judge to recuse himself of a particular matter. And I think that the public is particularly interested in Cecilia Dapa's case, and we are interested. Like you said, from
and now FBI has come in.
FBI and all that. I was taken aback to learn that FBI has come into this matter, Ketsi, the special prosecutor. I think that we have to differentiate the office of the special prosecutor from the person of lawyer Kisi Ejabin. People are confusing the two and they are taking him on personally. That is why I think it's most unfortunate. We must understand the law that set out that office and the remit within which he working. So for all you know,
those who are actually insulting him and his competence are MPP people. So you disagree and you want to tell them to stop doing that?
Yes, of course. I mean, you don't have to. I mean, the fact that you've been given
those who don't know a quarter of the law
you've been given a job to do, you are working within the remit of the law. And like you rightly said, people did not even know that the Section 2 of the OSP Act mandate him to prosecute. So they thought that you only go and
prosecute, recover, and prevent.
So his remit is so huge. So people thought that we'll go and make an arrest and hand the person over to the police. No. In the same way, we'll challenge the remit within which he works. If he goes beyond his remit, we'll challenge it. So for me, if you're an MPP person, the president has given him a job. First of all, you have to check. I mean, if any of us finds ourselves at the wrong side of the law, and Madam Cecilia Dapa is an MPP person, she's a mother and everything, you pray and you assist him legally, whichever way possible you think can circumvent these whole processes. Other than insult, if you insult him, today, if Kisi Ejabin is no more the special prosecutor, the office is still there. The piece of legislation that set it out has not been changed. So it will be applied.
Do you even feel that some of the attacks can discourage? Because somebody will,
obviously,
what is it? Is this my mother's or father's work? Please let me give their jobs to them.
The fight against corruption is not an easy task. And you need every state institution, every interested party to collaborate to ensure that we fight against corruption. And those attackers obviously are not pleased with the extent of corruption in our country. It is not today. People are asking, why hasn't the previous... I mean, he's not been appointed to prosecute former officers of the former administration. You are working, and if you are found guilty of the law...
There's this guy, Sir Obama, who is also a staunch MPP guy, but he can be impartial in the way he raises his criticisms. Very constructive. He says to those MPP people who are doing this that when Kisi Ejabi came in, all persons who are politically colored and who were accused of some corruption matters or some crime had already been put before court by the Attorney General. Exactly. So the OSP that you are expecting to go and look for NDC people, there are no more NDC people ready to be prosecuted.
I mean, someone has even been jailed.
So why are you attacking him?
Someone has even been convicted.
Exactly.
You know, I remember the NCA case.
That's correct.
Other cases have been prosecuted and some have been convicted. I think that we have to be patient in this country and really get information about how systems work. And I think the OSP may not have or doesn't even have a personal issue with Madam Cecilia Dapa. It's by virtue of the fact that he's the leader of that office. And you might be surprised to know that some of the advice may be professed by some other subordinates in that office. It's like the Attorney General's office.
Because he's not in charge of prosecution.
He's not in charge of prosecution. These advice that the Attorney General professes of being forwarded to the CID in respect of what we're talking about. Generally, perhaps other officers who profess legalistic opinion and will be forwarded to the AG to see.
Okay.
Many a times the AG does not write opinions personally.
Right.
But these are seasoned lawyers that have worked.
No, the AG's advice we are going to look at now. He didn't write it. It was Kilson who did the advice. But it's the AG who is taking all the flack. Yes.
Something I think this whole, OSP position is a learning curve, even for the occupant of the position. Mm-hmm. And the institutions within the judiciary itself, and all of us. So a lot of things are happening that perhaps many of us don't understand, especially those of us who are not lawyers. It may have our own interpretation because of the idea that a special prosecutor has been brought in to basically look for corrupt people. I mean, that is the general, perception. But the difficulty for me, and then he's the second occupant.
Perception or reality, that's why he was set up.
Well, the reality.
Prosecute corruption.
Yes. So,
and we agreed that attorney generals are ministers of justice. They sit in cabinet. They can't prosecute their own.
So the boundaries are probably not clear to everyone, though we know that is his job. But, how far does he go? And these are some of the things that we are talking about. But I said the challenge for me, as he is the second occupant, we know what happened to the first occupant, and then the second one. It's beginning to look like that position is given to you, and then your hands are tied behind your back, to do the job. It is also the belief that there might be people, not the person who made the appointment, but there might be people trying to make the job of the special prosecutor difficult for him by using all available.
So what should the person who made the appointment and people who matter be saying to those other people?
Well, I think, yes, here you may be talking about the president, or you are talking about the president. But I think, and I'm not defending the president, in his view, he might be thinking that, okay, this is an independent position that you have been appointed to go and do your job. So I am not going to interfere. But I think if he gets to a certain point, he himself being a lawyer, it will help by coming in if he really, wants to deal with issues of corruption, to come and somehow stamp his authority on the position that he has created, but still allow, But there is this belief, because the first one was not successful. And then he came out with all the reasons why he wasn't.
But a quick one, let me find out.
Yeah.
This statement from the OSP, was it directed to the said judge or to the media? Or a petition that he doesn't want?
CJ.
He's made a petition.
To the CJ.
Yeah, that's a
so we don't know the content.
It will be difficult to put the content out there. This will be held in camera. So people should be patient. I'm not sure he will just make a statement on nothing. Obviously, he has reasons.
Sure. I mean, obviously, we have
should
to
wait for the CJ's position in this matter.
Yeah.
Okay.
But I think there's a level of frustration, that something is not going right. I mean, this, as I said, this is the second person put in that position.
Right.
And we were not successful the first one. And the second one doesn't seem to be, going anywhere quicker.
That's what I say. When I hear people say that the OSP is turning into a monster, I say I thank President Akufo-Addo and Parliament. Only a monster can fight and prevent the monster of corruption that is impoverishing, an otherwise wealthy nation. And the prevention of corruption is such a monstrous, onerous job for the OSP that it needs our help. That doesn't mean that when they are not doing the right thing, we can't criticize them. Yes. Okay, so we take a pause on this matter here, and then we return to look at Professor Frimpong Boateng and his report, which the Attorney General has advised the police that there's nothing in there to prosecute those people that the professor indicts with his allegations. We'll be right back.